Democratic attorneys general from 20 states, as well as Washington, D.C., are now suing the Trump administration. This is after the administration announced on Tuesday that it would fire around 1,300 workers. That's roughly half of the workforce at the Department of Education. Now, Trump has repeatedly stated that he wants to return education back to the states. Meanwhile, in a separate case, U.S. District Judge William Alsup ruled that the Office of Personnel Management cannot order federal employees to be fired. And another federal judge issued a temporary restraining order that blocks layoffs across 18 departments and federal agencies. This could lead to thousands of fired workers being reinstated. Joining us now to break this all down is Alyse Adamson, legal analyst and former federal prosecutor. Alyse, thank you for coming on today. Let me ask you about what the plaintiffs are saying here, right? They're saying that these firings will incapacitate key statutorily mandated functions of the department. But then I also have the statement here from the Education Department's Deputy Assistant Secretary for Communications. It says these firings, they're strategic, internal-facing cuts that will not directly impact students and families. What's your take on all of this?
Yes, thank you so much for having me, first and foremost. So that's an interesting statement from the Department of Education. It actually strikes to the heart of the plaintiff's contentions, really, which is that these firings are tantamount to a gutting of the department, so much so that the department can no longer execute its core functions. And why is that important? Because the executive branch, that being President Trump and the heads of his department, they do have statutory authority to make all personnel decisions. They can issue RIFs, that means fire people, but the agency itself is congressionally created, meaning only an act of Congress can abolish it. So the plaintiffs in this case are arguing they're making so many cuts that the agency cannot carry out its core functions. And now what the department is saying is no, there won't be impacts to families. And indeed, they are going to be able to implement their core functions. And if that is actually true, then the plaintiffs are now on very shaky legal grounds.
Alyse, talk to us about the Administrative Procedure Act. I mean, how does that apply here? Why do the plaintiffs argue that these layoffs are arbitrary and capricious?
Well, they're arguing that there's really no bases for these layoffs because, of course, under the APA and under other regulatory authority, even though the executive branch has the authority to lay them off, there is a regulatory scheme in doing so. And from what we've known from the reporting and what the plaintiffs are alleging is that the layoffs are really justified under those regulatory schemes. It's not budgetary reasons. There's no performance-based reasons. It's all really just a cover to reduce the agency so that it can no longer function. Because recall, President Trump has said very publicly that he wants to dismantle the Department of Education. But what he has said publicly and what is happening legally are indeed two very different things.
So how strong of a case, you mentioned there that plaintiffs could have a shaky case in a specific situation, but right now, how strong of a case do they have in terms of claims that these layoffs are part of a broader illegal plan from the Trump administration to really dismantle the education department?
Yeah, that's a great question. And I'm going to give you the lawyerly answer, which is it depends, right? This is a very early stage of litigation. If you read the complaint like I did, you see a lot of the allegations are framed upon information and belief. And that's because they just don't have a lot of information yet. They have not started the discovery phase. This is all based upon what they have been told. I think if you credit all the allegations as true, then I think the plaintiffs do have a semi-strong case. If indeed the agency cannot administer its core functions, then I think there is an argument that the executive branch has exceeded its authority because at this point, it is preventing a congressionally created agency from doing its core functions. And you have to remember, under the separations of power, each branch does have its own separate authority, which the other branch cannot infringe upon. And so if all of those are true, then I think they have an argument. And the very simple way to address their argument is that the executive branch has simply gone too far. They can issue RIFs, but they cannot RIF employees so much so that the agency cannot function. And so if they're true, I think it's a strong case. But if the Department of Education's assertion in its press release is true, that indeed they do have enough workforce to go in and continue to administer the core function of the agency, then that undermines the plaintiff's argument. And I would also note that there is a way to abolish the Department of Education with no questions asked, and that would be through an act of Congress. And Linda McMahon, who is the secretary of the Department of Education, is actually quoted in the plaintiff's complaint by saying that she intends to work with Congress to achieve that. And so, while I do think that some of the claims have some validity, I also think there is a much easier way to address this if it is the will of Congress.
And talk to us more about that from the Trump administration's point of view. How can they go about proving, these cuts, they're not going to affect education or these essential programs for disabled students or student loans?
Sure. I don't think that legally the executive branch needs to prove that it's not going to impact some of the programming. Of course, policy priorities shift. That's all within the purview of the executive branch. Of course, they have Title V authority to administer these agencies, and they have oversight over the personnel, and they can make personnel decisions. So there can be impacts. The question is whether or not all of these cuts prevent the agencies from administering their core functions. And I think what the Trump administration, or more specifically the Department of Education, will have to demonstrate to defeat this claim is that indeed they have enough employees to administer their statutorily required duties. And that's very, very specific, because they don't need to be doing it flush with money. They just need to be able to do it. The reduction of force is about 50%. So they just need to show that with half of their workforce, they are still able to administer their core functions and satisfy their statutory obligations.
So, as we did mention earlier, Trump, a big goal of his is really to move education back to the states. Now, of course, all of this is very preliminary, and we're not sure where it's going to end up going. But if this were to be the case, where these responsibilities were starting to be put back onto the states and the federal government had less of a role, what kind of legal courses could these attorneys general or other lawmakers take to ensure that there's still some sort of a protection system in place for education?
That's a great question, and I don't have a satisfying answer, because at this point, we've never seen anything like this. This is unprecedented. Of course, the Department of Education hasn't always existed, and so there were mechanisms for administering education, but it was never uniform like it is now within the United States. And so the question of how is this going to look? How will there be protections? How can we ensure education for everyone is something that is going to need to be tackled. I think that's one of the reasons that Congress ultimately will not abolish the Department of Education. But I think the answer is, unfortunately, we're just going to have to see.
Now, Alyse, along a similar line, I want to ask you about those two federal judges that we saw ordering the Trump administration to really essentially reinstate thousands of fired probationary government workers. But then we also saw government lawmakers saying that these firings were lawful because these individual agencies had already reviewed and determined whether these workers were fit for employment. What do you make of this entire situation?
Yeah, I think that this is a really tough situation that's going to be litigated through the court system. So the judge in San Francisco yesterday essentially said that the government had not demonstrated that the proper procedures for termination were carried out before all of these probationary employees were terminated, that essentially it was a sham. I think that was the word he used from the bench, that they couldn't have gone through all of their files and made a performance determination and ordered their reinstatement accordingly. So what they're basically saying is, you did not follow the regulations, and you need to do this if you want to terminate these employees. Not that they don't have the power to, but that they didn't do it in the right way. So one has been ordered for reinstatement. There's another case that they issued an injunction, meaning that they can't move forward with terminations. I think what we're going to see is this case is going to go up to the appellate court, especially the San Francisco case. It would go up to the Ninth Circuit. And I think it's ultimately going to end up in the Supreme Court. Now, I think what they need to litigate, because the issue is really, has this been done properly, is the question, has this been done properly? And the government is saying that it has, but they're going to have to take evidence and find out whether or not that is true. And sitting here now, I don't know whether it's true. I can tell you that the judge in San Francisco was incredibly skeptical and said that he wasn't sure that the government's lawyers were being truthful. I think those are very strong statements from the bench, indicating that he's just not believing the representations that a thorough review was done of these terminated employees.
So, based on what you're saying, Alice, do you see any sort of concern that the judicial branch might be encroaching on the executive branch's power?
I think that's certainly the argument. I think that the Trump administration's position is everything it's doing is well within their authority as the executive branch, because as we already discussed, the executive branch does have the authority to make personnel decisions. I think the hard part is if these decisions are not being made in accordance to the law, well, then all of a sudden there's a bigger question. The executive branch, the executive has the take care clause. It must abide by the take care clause, which means that he must abide by all laws and implement them faithfully. And if that is not happening, then it's not so much an infringement on executive power, then it's going to be an infringement on congressional power and all the other powers as well. So I don't think it's wrong that the matters are being litigated. They're going to take evidence and they're going to make sure that these procedures were followed. I think if there are findings that the procedures were followed properly, well, then I think it is within the purview of the executive branch to lay off these individuals, and these terminations are going to be found to have been lawful.
It's going to be really interesting to see what comes out of these lawsuits. Alyse Adamson, thank you for joining us.
Thank you for having me.